Welcome to the NJ Criminal Podcast and part 3 in this series.
Especially with our young folks, they're afraid. They're afraid to get dirty. They're afraid to get bloody a little bit. They think it's going to kill them. And it's just not the case. You learn a lot more from your failures than you do from your successes, because there's such confirmation bias. When you win something, it's very easy not to be introspective because it worked. Whatever you did, frankly, with a lot of luck, usually it just worked. So I have always been the one that needed to prove the existence of electricity by sticking my own finger in the socket and getting a shock.
Yeah.
And if people can gain some benefit by hearing it from me, that's great. But I would encourage anybody to dare, and to dare greatly. Don't be on the sidelines. Don't be the naysayer. Don't be too timid to try something. Even here, we had a case, Meg, and this was, it's a shame because probably most of the cases that I can talk about are that just have terrible, terrible facts. But we had a case here where pretty recently, this was the last one that I tried, actually, and I have a lot of help now because I'm not as nimble as I used to be in court. I'm not in court as much. I have to manage the whole office. But this was an awful case in which this mother of a 14-year-old girl and the mother's boyfriend essentially plotted to kidnap and rape and assault and then murder this 14-year-old girl. And they carried it out. They did do that. And this young girl was Grace Packer. God rest her soul. And so we went through the process. And this poor Grace, she had such a tortured history. It was not her fault, but she had been abused before. She was adopted by this lady. And the lady just kind of viewed her, I think, as a paycheck from the government. And that's how she treated her. She would keep her locked in a bedroom until finally, I think they just felt she was more trouble than she was worth. She really never had a chance. And my overarching theme of the case was there is no such thing as a disposable child. No child is disposable. And as it turned out, we somehow, and this is, if I can dovetail a lesson in here, we have a very collegial bar association here, meaning that our district attorneys from the top down and back up get along very well with our defense bar. And one way or another, we were able to make it palatable for that mother to plead guilty to first-degree murder and take a life sentence, which in Pennsylvania means you serve the rest of your life in prison. And
life,
then the
life
boyfriend,
is life in PA?
Yes, it is. Yes, it is. And then the boyfriend, and this was through this collegiality because the top public defender represented this guy, and she had a team, and I had a team as well, and we would collaborate a lot, meaning not on like, hey, this is how this is all going to the outcome, but on what are the issues? What can I concede to make this go smoother, meaning on my side, and how can we just we just need to contest the issues. And we were able to come to an agreement on, I'd say, 90% of all the issues, which was amazing, to the point, Meg, where the guy actually pleaded guilty to doing it. And then we impaneled a jury to determine whether he would get life in prison or the death penalty. And that was the only issue.
So he pled guilty, and the only issue was the bifurcation of the sentencing.
Yeah, which is extraordinarily rare.
Mm-hmm.
And one of the things that I did was I conceded to him that he could use as a mitigator, and I don't want to get too in the weeds, but in his favor, that his co-defendant had already gotten a life sentence, that the jury could hear that. And that's not permitted, really, in Pennsylvania. I could have fought very easily and excluded that because this was an extrajudicial mitigator. And I felt like, look, this guy should have a chance to fight for his life, even though I have my own opinions on what the outcome should be, that he should have an opportunity to present that. And he did. And the jury sentenced him to death. And he ended up going to jail, and he lasted about a year or two, and he died in prison. So, if you believe in God, you could say that's just desserts or what have you. But that was an extraordinary case in which we collaborated with the opposition in all but the result. And I believe that the right result was justly reached. But I've also had murder cases where I've lost. I had a 6-week jury trial in Lehigh County on a murder case where the young man had a pretty good self-defense argument. The case was it was charged before I got involved. Maybe had I been involved, it might not have been charged. I don't know. And my boss insisted, look, you got to take this in. I said, okay, I think I have an argument. And I made the best argument I could, and the jury found him not guilty after 6 weeks. And although, our competitive nature takes over, certainly, you got to play by the rules. And if that's the jury's verdict, so be it. So be it. And I've come to accept it.
It's hard. Those kind of losses are hard.
Certainly.
But going back to what you said a couple minutes ago about, reaching stipulations, that kind of analysis, I think, only comes with a lot of experience. In other words, being able to, pick your battles, so to speak. And I think that that's something that sometimes attorneys feel that they have to fight tooth and nail every single step of the way. But at the end of the day, I think, if you put your heads together, it's pretty clear what the actual issues are. And I think that helps focus all sides, and particularly the jury as well.
I agree with you, Meg. I think it comes with confidence. It comes with confidence and experience. It's like, let's cut to the chase. What's important in this case? What's really the issue that's unresolved? And let's try to agree to everything else. But I can. Do I have time for one more story here?
Please go ahead. I'd love to.
So this was a case. I felt like I was always inheriting other people's cases down in Cape May County.
You did, yeah.
It was
the hot potato cases ended on your desk, I think, sometimes.
You know what it always seemed to me like? You remember that old Life cereal commercial? I'm not going to try it, you try it. I'm not going to try it, you try it. Let's get Mikey. And I was Mikey. So
yeah.
I got
I heard
a lot of
I heard that's not why you left.
No. I left for a shot at greatness, and here I am. So I'm still working on that part. But I had a case down in Cape May County, and it was a retrial. In an unfortunate circumstance, it was a dad that had raped his young daughter, and the dad. This was the craziest part. He had served a 10-year sentence, but finally got his appeal granted and got a new trial. This was crazy. So the case was tried before Judge Batten, and I was the original prosecutor had retired and taken another position. And so I got assigned the case, and in the interim, the young lady who was so brave and so courageous, but this was the only family she had, she recanted once her dad went to jail, so that she could be reunited with her family. And that recantation was recorded. And then the guy got let out, and he appealed, and he won his appeal. And so that was some terrible facts. But she was back. She was on board. She testified bravely and courageously. But I think the reason that I'm telling this story is because the defense attorney on the other side was so focused on me that she lost sight of the triable issues in the case. The recantation, there were so many issues. The age of the case, which the jury wasn't even permitted to know. Obviously, you couldn't know this was a retrial. And at the very end of the case, I will never forget this. So it's my turn to close, and I have a tendency, Meg, to really let the defense attorney say and do anything they want in their closing argument, because I know I get to go
You
last.
get the last word, right? As the prosecutor, you always get the first word and the last word.
Yeah. So my philosophy is, you give it your best shot. I get to clean it all up and then some afterwards. And then what happened was, and I never saw this happen before. This defense attorney, it was my turn. Oh, well, I got to back up. I'll take a 2-minute diversion. So in the original trial, the defendant did not testify. And I thought that was, as it turns out, it was a very smart move, because we put on our case, and Meg, you know that feeling of relief when you're done your case, it all comes pouring out, and hopefully it goes in well. And the judge is like, call your next witness, and you say, Judge, in New Jersey, the state rests its case. And you feel this sense of relief. But the case isn't over. So Judge Batten then turns to the defense attorney and says to her, would you like to put on a case? And in the original case, there was no defense. It was basically the prosecutor had to meet his burden. And she immediately says, I called the defendant, Mr. What's-his-name, to testify, thinking she would catch me off guard. But what she didn't know is, like, I am salivating at this opportunity because, of course, just like you, I was prepared. He had given prior statements. They were recorded. There was all kinds of great stuff in there. And so this guy gets on the stand, and, she had prepared him, so he does okay. And then I have miles and miles of cross-examination to go through with this guy. And he's not doing so great, but he's holding his own. Till finally, Meg, and I still have like hours to go with this guy, I ask him a question, and it had to do with like his drinking. And he says something like, I am 70% sure I did not rape my daughter. And you could have heard a pin drop.
Wow.
And I'm like, what did that guy just say? So
could you repeat
I immediately,
that?
well,
you almost want to sit. You almost want to sit down. No further questions.
Well, so I'm still. Oh, you're reading my mind. Mm-hmm. So I gathered myself, and because I knew this guy was kind of malleable, but he said it, and so I say to him, so I'm doing some quick math. Does that mean you're 30% sure you did rape your daughter? And he said yes. And then, Meg, I shut my notepad. I close all that. I'm like, no further questions, just like you anticipated. I was stunned. It was the jury, they stopped eating their proverbial popcorn. Their mouths were dropped. Everybody was agape. And it was nuts. But so then, obviously, the case went great. So then the defense attorney gives her closing. And this is the thing I had never seen before. It's time for me to give my closing. The defense attorney takes her notepad and goes and sits next to the jury. Have you ever seen that before?
Never.
So I'm like, wait, I have an idea. So, and my practice is never to object when the defense gives a closing, and I rarely object anyway. And the first thing I say to the jury is this, and I'm staring right at her. I say, look, you've seen me and the defense attorney. This has been a very hotly contested case. You can appreciate this because this guy's fighting for his freedom, and I'm fighting for this young lady. And so this case means a lot to both of us. So please forgive us if we've seen unprofessional or we've acted out of turn. But you'll also notice that I did not object not one time for her closing argument, because I know what she has to say is very important, and she's fighting for her client's freedom. I said, so I hope that she will give me the same grace and let me say to you what I need to say to you uninterrupted. And you should have seen her. She goes, hum, 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 puts her pad down. She crosses her arms. She went for it. So I'm giving the closing, I figure I'm giving the closing of my lifetime. She's not going to interrupt me. She's got to sit there now and stare at me and not object to all my stuff. And then at the end of the closing, the judge is like, okay, send the jury out. Or no, he calls us both up and he says, Mr. Weintraub, do you have anything? I'm like, nah, I'm good, Judge. And he says to the defense attorney, do you have anything you'd like to say? She's like, well, I have all these objections that I've noted on my notepad that I'd like to make now. And the judge is like, well, you should have made them while they were timely. And so she didn't get to make a single objection. It was incredible. And that guy got found guilty. And here's the craziest part. Because something strange happened in the beginning, in the first trial, the guy got a 10-year, like it was an agreed sentence. It was a stipulated trial. I'm not sure. But the judge in the first trial didn't go through all the factors, you know, the aggravating, the equipoise, the mitigating. So Judge Batten did. And because of the factors, he sentenced him to an additional 5 years, Meg. The guy had to go back to jail. It was incredible.
Wow.
But
there's some of the stories that you can't make up. I mean, that's real life right there.
Stay tuned for the next part in this conversation. This podcast is not a source of legal advice. No two legal cases are the same. Contact an attorney if you require legal assistance.